The lawsuit arrived by certified mail on a Tuesday afternoon, claiming that the flagpole standing in my front yard violated Section 9 of the Brightmoor Estates architectural guidelines, exceeded the maximum permitted structure height by nearly 6 feet, and had never received proper association approval before installation. I want to be honest that reading through those first 2 pages, I felt something closer to quiet amusement than actual concern, mostly because I happen to know, with a certainty very few homeowners in that situation would have, exactly where the real permit records for that flagpole were sitting, since I own the building they were filed in. My name is Roland Ashby. I'm 52 years old, and I've spent the last 20 years working as a commercial real estate investor, building a modest portfolio of small office buildings throughout the county, one of which happens to be a 2-story brick building downtown that I've leased, for the past 11 years, to the county government itself for use as their planning and permits office, the exact department responsible for reviewing and approving residential structure permits throughout the entire county, Brightmoor Estates included. I want to be clear that I don't work for the county myself, and I've never had any official role in reviewing or approving permits. I simply own the building, which meant, over 11 years of collecting rent checks and occasionally stopping by to address a maintenance issue, I'd got to know the department's actual filing and records process reasonably well, considerably better than the average homeowner ever bothers to learn. That knowledge turned out to matter a great deal once Marisol Kettering, president of the Brightmoor Estates Homeowners Association, decided my flagpole represented a serious enough violation to warrant a formal lawsuit rather than, say, a simple phone call asking whether I actually had a permit for it. I installed that flagpole about 4 years ago, a straightforward 25-foot aluminum pole set in a concrete footing at the corner of my front yard, the kind of modest patriotic display you'll find in plenty of yards throughout any given neighborhood in this country. I want to be equally clear that I did, in fact, obtain a proper permit before installation, precisely because owning that county building had taught me, better than most people ever learn, exactly how important it is to have your paperwork in order before a project like that ever gets underway. I'd filed the application myself in person at the County Planning and Permits Office, paid the modest filing fee, and received formal written approval roughly 2 weeks later, all of it properly documented, and as it turned out, still sitting in the county's own filing system exactly where I'd left it 4 years earlier. Marisol's lawsuit, when I finally got past the opening claims and read through the full complaint, asserted that Brightmoor Estates' own Architectural Review Committee had never approved the flagpole's height. That association bylaws required committee sign-off for any structure exceeding 15 feet regardless of county permitting, and that my failure to seek that approval constituted a clear violation warranting removal of the flagpole, along with what the complaint described as reasonable attorney fees and costs. I called an attorney the same week, a sharp, methodical woman named Perpetua Alderidge, who'd handled property and homeowners association disputes throughout the county for the better part of 2 decades. I laid out the situation for her, including the detail about the county permit office that made this particular dispute feel, to me at least, considerably less intimidating than it probably would have felt to most homeowners receiving that same certified letter. The association bylaws requiring architectural committee approval alongside county permitting isn't unusual, Perpetua told me, once she'd reviewed the lawsuit and the association's governing documents. Plenty of associations layer their own design review on top of whatever the county requires. The question here isn't whether that requirement exists on paper. It's whether it's been consistently enforced, and whether the association can actually demonstrate you were properly notified of it at the time you installed the pole. I mentioned, at that point, that I happen to know the county's permit filing system reasonably well, given my own building ownership, and offered to pull whatever records might be relevant myself. Since the flagpole permit itself would be sitting in a public file, I had every legal right to access the same as any other member of the public. I drove down to that familiar building the following morning, greeted the same records clerk I'd exchanged pleasant small talk with for years while collecting rent checks, and requested a full copy of my own Flagpole Permit file, along with, since I was already there, a general search of any permits filed for structures throughout Brightmoor estates over the preceding decade. The clerk, a patient woman named Delphine Ose, who'd worked in that department for as long as I'd owned the building, pulled my file within minutes. My original application, the approval letter, and the inspection sign-off confirming the pole had been installed to code, all sitting exactly where I remembered leaving them 4 years earlier. "While I'm here," I said, "would you mind pulling any permits filed for the Brightmoor Estates community clubhouse and pool structure? I'm just curious whether the association went through the same process I did." Delphine ran the search and came back with an answer that genuinely surprised me, given how confidently Marisol's lawsuit had characterized my own failure to seek proper approval. There was no permit on file for the clubhouse's rear pergola addition, constructed roughly 3 years earlier according to the association's own newsletter archives. A structure that, based on the photographs I'd seen at community events over the years, stood considerably taller than my own flagpole. I want to explain why that discovery mattered so much to the overall situation, because it reframed the entire dispute in a way Marisol's lawsuit clearly hadn't anticipated. If Brightmoor Estates intended to enforce a strict height restriction requiring both county permitting and architectural committee approval for any structure exceeding 15 feet, consistency would require applying that same standard to the association's own construction projects, not just to individual homeowners the board happened to have singled out. Perpetua's response to Marisol's lawsuit, once we'd gathered this documentation, laid out a straightforward counterargument. My flagpole had, in fact, received proper county permitting, satisfying the underlying safety and structural review purpose behind any height restriction in the first place. The association's own claim that architectural committee approval was separately and strictly required, meanwhile, appeared to have gone entirely unenforced against the association's own recently constructed clubhouse pergola, a structure considerably larger and more permanent than a simple flagpole, raising a fairly obvious question about selective enforcement. Selective enforcement doesn't automatically invalidate a legitimate rule, Perpetua explained to me, but it does undermine an association's credibility significantly when they're asking a court to strictly enforce a provision against one homeowner while apparently ignoring the exact same provision for their own construction projects. Marisol's response, once Perpetua's counterfiling landed, attempted to distinguish the clubhouse pergola as a community amenity project approved directly by board vote, rather than requiring the same architectural committee review applicable to individual homeowner structures, an argument that struck me, and eventually the court, as considerably more convenient than it was persuasive, given that nothing in the association's own recorded bylaws actually drew that particular distinction anywhere. I want to describe the moment this entire situation shifted decisively in my favor, because it happened almost by accident, the way these things sometimes do. During a scheduling conference for the case, Marisol's own attorney mentioned, somewhat defensively, that the board had relied on outside legal counsel's advice regarding the pergola project's compliance status, a comment that prompted Perpetua to formally request copies of whatever legal opinion the board had actually received. That request produced, after some delay, a brief internal memo from the association's attorney at the time, dated shortly before the pergola construction began, explicitly advising the board that the structure would likely require the same architectural committee approval process applicable to any homeowner project of similar scale, and recommending the board formally seek that approval before proceeding, advice the board had apparently simply chosen not to follow. I want to be fair and note that I never set out, at any point in this dispute, to embarrass Marisol Kettering personally, or to turn a straightforward flagpole disagreement into some kind of broader indictment of the entire association's governance. My goal from the very beginning was simply to demonstrate that my own flagpole had been properly permitted, and that the lawsuit against me lacked any legitimate basis. Given documentation, I happened to have unusually convenient access to thanks to my own unrelated business dealings with the county. But once that internal legal memo surfaced, showing the board had been explicitly advised to seek the same approval they were now suing me for allegedly skipping, and had simply declined to follow that advice for their own project, the dispute stopped being a simple disagreement over flagpole height and became something considerably more difficult for the association to walk back from gracefully. The judge overseeing the case scheduled a hearing roughly 6 weeks after that memo surfaced, and I want to describe it plainly rather than dramatically, because the actual proceeding was considerably less theatrical than these things sometimes get portrayed. Perpetua presented my county permit documentation first, establishing clearly that the flagpole had received proper approval through the same process any homeowner in the county would follow. Then she presented the Pergola Permit search showing no county filing existed for that structure at all, followed by the internal legal memo advising the board to seek architectural committee approval, advice they had documented and then ignored. Marisol, called to testify regarding the board's decision-making process, struggled to explain why the association had pursued strict enforcement against my flagpole, while apparently disregarding their own attorney's explicit written recommendation regarding the clubhouse project. Her answer, when it finally came, amounted to little more than an assertion that community amenity projects were understood differently than individual homeowner structures, an understanding that, as Perpetua pointed out plainly, existed nowhere in the association's actual recorded governing documents. The judge's ruling, issued about 2 weeks after that hearing, dismissed the association's lawsuit entirely, finding that my flagpole satisfied the underlying county permitting requirement, and that the association's inconsistent enforcement of its own architectural review standard undermined any claim that the height restriction had been applied in good faith across the community. The ruling also awarded a portion of my legal costs, given the court's finding that the lawsuit had proceeded despite documentation, readily available through the same public permit records I'd accessed myself, showing my flagpole was properly authorized from the very beginning. Word of the ruling spread through Brightmoor estates considerably faster than I expected, particularly once several residents realized the clubhouse pergola, an amenity most of them had enjoyed for 3 years without ever questioning its compliance status, had apparently never been properly permitted at all, despite the board's own attorney explicitly advising them to seek that approval before construction began. The Brightmoor Estates Board held an emergency session shortly after the ruling became public, and I attended, mostly out of simple curiosity about how the situation would ultimately resolve, along with Delphine Osai, who'd offered to speak plainly about the permit search results if the board had any remaining questions about the documentation itself. A board member named Terrence Whitfield, who I understood had joined the board only within the previous year, and had, by his own account, always assumed the pergola project had been properly vetted before construction, asked Marisol directly why the board had proceeded despite their own attorney's written recommendation to seek architectural approval first. Marisol's answer offered little beyond an acknowledgement that the board had, in her words, prioritized completing the amenity ahead of an upcoming community event, rather than delaying construction for what she characterized as a procedural formality, an explanation that satisfied nobody in that room, particularly given that the exact same procedural formality had formed the entire basis of the lawsuit filed against me. The board voted that same night to formally withdraw any further enforcement action related to my flagpole, to retroactively seek proper permitting for the clubhouse pergola, a process that ultimately required a modest structural modification once the county's actual inspection revealed a support beam that hadn't been installed to code, and to adopt a revised policy requiring the board to follow its own attorney's written recommendations on any future construction project, rather than proceeding around them when convenient. Marisol resigned from the board position within the month, and Terrence Whitfield stepped in as interim president. One of his first actions being a full review of every structure throughout the community to confirm proper permitting existed across the board. A review that, once completed, turned up 2 additional minor discrepancies unrelated to my own case, both quietly resolved through straightforward retroactive permit applications. My flagpole still stands exactly where it did 4 years ago, properly permitted then and properly documented now beyond any further dispute. And I'll admit there's a particular satisfaction in knowing that a lawsuit intended to force its removal, instead, ended up requiring the association to retrofit their own clubhouse addition to meet the exact standard they'd tried to hold me to. I still own that same downtown building, still collect the same rent checks from the county each month. And I've found, since all of this settled, a renewed appreciation for the simple, unglamorous value of knowing exactly where your own paperwork lives, and being willing to actually go check it before assuming the other side's version of events is the accurate one. If this story hit home for you, do me a favor and hit that like button. It genuinely helps this channel keep growing. And if you haven't already, go ahead and subscribe so you don't miss the next one, because there are plenty more stories just like this one still to come. Drop a comment down below and let me know what you thought of this one, or whether you've ever had an association try to enforce a rule against you that they weren't following themselves. I read every single comment, and honestly, some of the best stories on this channel started as a comment somebody left on a video just like this.